case number 116818, Sally Scribner v. Board of Education of USD number 492 et al.
If it pleases the court, my name is David Schauner, appearing on behalf of the appellant. And before I forget, I'd like to reserve 5 minutes for rebuttal.
5 minutes is granted.
Thank you. This matter arises today as an appeal from the Butler County District Court and arises out of an action taken by the Kansas legislature in 2014, amending the Kansas due process statutes that apply to certified teachers in Kansas K through 12. That matter was challenged in the district court in Butler County, and the court there found adverse to the appellant. We're here today to ask this court to review the underlying facts and the constitutionality of the statute, and we're prepared for argument. This matter arose in April of 2014, and it arose in an odd sort of way. The legislature was under the gun, so to speak, to pass some funding legislation in response to the court's decision in Gannon. On the 3rd of, early in April of 2014, House Bill 2506 was enrolled. There were hearings, and that bill was a bill to talk about making some changes in the Midwest Higher Education Compact. However, on the 3rd of April that year, that bill was gutted and substituted for what became known as Senate substitute for House Bill 2506. That bill was then amended a number of times by interested parties, and the one that we're here today and concerned about is the amendment offered by Senator Arpke on Friday, April 3rd. And that amendment had the following impact. It changed the definition of teacher and removed from that definition those persons who were employed by a K-12 school district. It left intact coverage, due process coverage, for those persons who were working for a community college or a technical college. The impact of that was that all of those persons who had earned a tenured position, property if you will, were no longer holders of that property. So I would start with my first question is, were these folks tenured? My two clients were highly qualified veteran teachers in Kansas, had earned due process rights, and I submit to you that they had earned a property interest in that employment.
Counsel, in that regard, are you familiar with the case out of North Carolina from a couple of years ago that talked about the continuing contract law and basically I would read it as supporting your position? You didn't cite it in here. So my first question is, are you aware of the case?
Oh, absolutely, I am aware
so
of the case.
Now my question is, how is the case that you're presenting to us different from that case?
Well,
I guess I'm trying to say I'm surprised those arguments aren't here.
It was our opinion that the contract provisions in North Carolina were different than the contract provisions which might be available to teachers in Kansas. But rather, in Kansas, there is a strong property interest that was taken from these plaintiffs by action of the legislature without either notice or opportunity to be heard on the substantive matter of their property loss. Essentially, a taking without notice or opportunity to respond.
So from that, I don't know quite how to ask this, so bear with me, but it doesn't seem to me like your case is predicated on the provisions of your client's actual contract.
I believe that to be accurate.
Okay. And then just one final thing. So there's nothing in these teachers' contracts that we would look to. The chronology that I have is that this law is published in the Kansas Register on May 1st, but the statutory deadline for the school district to give notice to these teachers was May 15th of 2014, but 2506 provisions as to the teacher provisions didn't go into effect until July. So what I'm getting at is on May 15th of 2014, is there any reason to believe the old law embedded into the contract for the 2014-2015 school year? You get what I'm
I do. I think the closest reference would be the continuing contract law. And the notice, the concept of a notice on an annual basis by a fixed statutory day, a calendar date, is there to give notice to the teacher, whether they're tenured or not, that their contract's not going to be renewed for the following school year. There's nothing embedded directly in these appellants' contracts that say you have a property interest, but rather...
Or nothing that says we're putting into the 2014-2015 contract the law as it existed on May 15th. You see what I'm getting at?
That's correct. That's correct.
There's nothing in that contract that would grab that law other than the constitutional arguments that you're making.
That's correct. The action in this case took place at the close of the 14-15 school year, not at the close of the 13-14 school year. So the statutory date had already passed at the close of the 13-14 school year before this statute was passed.
The effective date preceded the termination of your clients.
It followed let's back up. In 2014, the statutory date for notice had passed. But for the 15 notice date, the statute was in place and had been effectively since July 1st of 2014.
Your clients were not terminated until that period of time.
That's correct. So one of the fundamental questions here is, if you believe, as I do, and as I believe this court has said many, many times since 1974, that teachers, after they serve a requisite number of years, earn a property right. And I'd refer you clearly to the
Before
McMillan
you go
case.
into that, can I back up just a minute, because I'm trying to figure out what your answers to the Justice Biles questions does to your second issue. Are you basically conceding your second issue?
I think our strongest issue is our property interest issue. The other side, the appellee here would have you believe two things. One, that under KSA 725444, these folks can never earn a property right or a contract right. Secondly, that these changes enacted in April of 2014 operated only prospectively and didn't have any impact, or rather, it did have an impact on my clients, but not an adverse action, because their only due process would have been available to them in a prospective manner. We disagree wholeheartedly with both of those contentions. In fact, this statute does have a retrospective, or retroactive rather, application. It takes away property that these clients had earned through their quality service to the school district, and they never had either notice or opportunity to respond to these changes in the law, which occurred in the wee hours of the morning of Saturday and Sunday of April 5th and 6th, 2014.
Is the problem the timing? The timing that Senator Arpke's amendment was offered didn't afford that? Had the amendment been offered earlier in the session when there was time to discuss this, presented at various committees, would that have satisfied due process in terms of the taking?
I think that there is reason to believe that had there been proper notice and opportunity, that under a reading of 5444, there could have been a change in the property interest status of my clients. That did not happen, however.
I understand, but that could have happened, given that typically we look to the legislative process to satisfy the due process requirements.
But there's this broad thing called legislative process, which is just a whole lot of stuff going on over there, and that's all sort of process. But legislative process in this case, under the Darling analysis, has to be more than just the legislature says yes and no. There has to be, under the 14th Amendment and under our Kansas Constitution, Articles 1 and 2, notice and reasonable opportunity to respond before property is taken, whether it's life, liberty, or your property. And clearly in this case, this court has ruled on a number of occasions, McMillan being one, Coates another, that there is a property interest earned by these teachers through quality, continuous service.
Do you concede that the legislature has the power and authority to eliminate this particular property interest?
Not unbridled.
Well, can they, under any circumstance, eliminate this property interest?
The legislature, once it gave this property to these folks as far back as 1974, reserved to itself the right to make changes in that.
So your answer is yes, the legislature has the power to eliminate the property interest that they granted.
My answer is, with proper safeguards, they had.
But the first question is, do they have the power to ever eliminate that interest?
With proper.
That's the preliminary question.
With proper safeguards, the answer is
So
yes.
the answer is yes. So that leads me to my second
Okay.
question. What is it you are saying the legislature had to do in order to properly exercise that authority to eliminate the property interest?
They had to provide notice, not individual notice to my two clients, but notice generally through their regular scheme of notifying the public about what they were doing. And
How do we know what their regular scheme is? I mean, why didn't this occur within the regular course of what they do?
Well, being cynical, I think they did it this way because it was sort of a midnight raid on these rights.
But whether it's cynical or not, we know the legislature often passes laws, quote unquote, this way.
It isn't just a matter of passing a law. It's a matter of taking somebody's property. That's different.
Well, but you've conceded that they have the power to take the property in
no.
response to my colleague's question, and you're complaining about the process.
I'm complaining about the form of the question because it's not just that they have power, it's that they must exercise it in a way that's consistent with the 14th Amendment and the Kansas Constitution, Articles 1 and 2. And they did not do that in this case.
What does the 14th Amendment require of a legislative body in order to legitimately exercise its power?
I believe the framers had a general fear of government. And they said in the the 14th Amendment and the 5th, as it applies to the federal government, you can't take someone's life or their liberty or their property without proper procedures, a notice and an opportunity to be heard. And the amount of all those things varies with the level of taking. In this case, having a legitimate fear of government is wise, because in this case, after regular business hours for most human beings, the legislature met on a weekend, in the middle of the night, amended this.
Is there any case in the country that says the 14th Amendment doesn't allow a state legislature to pass legislation in the middle of the night? That's not sufficient process.
It isn't just when they did it.
Well, is there any case in the country that holds the way you're asking us to hold?
Well, I can't cite you a case on those specific facts, but what I can cite you is a litany of cases which say that a bare legislative process in a taking without proper notice and opportunity to at least the class of persons that will be affected violates the 14th Amendment due process considerations.
So to go back to what the minimum that the legislature had to do to satisfy the 14th Amendment, what are those things?
Notice, reasonable notice.
And you've talked about general notice to blank. Who does that have to go to?
Well, to the public. The notice that they give to any citizen isn't necessarily particularized notice. They don't have to send it to David Shawner, but they have to put it out there in some way that I have an opportunity, if interested, to know about it.
In what way would that be?
Through their, now through websites, through their own website, through their own processes. In this case, they did nothing. They didn't do anything. It's not a matter of what were their processes. They didn't exercise a process other than a late on Friday amendment to a gut and go bill, a bill that they gutted and went with, changing the whole subject of it. It was a must pass bill. They ended up locking up the House chambers so nobody could leave because they couldn't come up with a 63rd vote. I mean, this was run through without any regard for whether anybody whose property was being taken would have an opportunity to respond before it was a fait accompli. And that's exactly what they did.
And to go back to Justice Stiegel's point, the gut and go, whether you like it or not, has been used rather frequently by the Kansas legislature, at least in recent years. Would you agree with that?
I would.
Okay. You take exception to their use of that device under these facts because a property interest was involved? Is that what you're telling us?
I would take issue with any process, gut and go or otherwise, that was intended to take my property and didn't at least give this class of folks a notice about it and an opportunity to weigh in.
So the 14th Amendment requires hearings. That's boiled down what you're
Well, it
saying.
requires notice and opportunity to respond.
And
Not
that-
necessarily
what-
a hearing.
Well, is there any other,
Well,
would any other process satisfy your
Well,
position?
I don't want to get hung up on how finite the process has to be. I think the notion is you look at the kind of process that was available in the context of what was being taken. And what was being taken was, in the case of my two clients, their livelihood.
We're
We're
asking how
trying
you
to
draw the
find
line.
out, I'm sorry,
That's all.
going back to my original question, we're trying to find out what is the minimum that the Kansas legislature could have done or should have done to satisfy your due process concerns. You've talked about general notice to the class of people whose property interest is being taken. Justice Stiegel asked you, well, is a hearing required? And you said, I don't want to get into the niceties. Well, I'm asking you to get into the niceties. What besides notice would be required to satisfy your view of the 14th Amendment?
Let me try this as a response. If there had been a notice in the regular course of business, we get notices all the time about a bill that's been introduced on some subject. If it had happened in that way and there had been a hearing scheduled, could have been a short hearing, but a hearing scheduled, and we'd had an opportunity to respond to it, that would have satisfied the notice and opportunity. But the problem,
I'm asking what the minimum is.
I think
Is a
that would be the
hearing- is-
minimum.
hearing
I think
is a
that would
minimum.
be the minimum.
Wasn't there opportunity for debate on the floor?
There was
of
not.
each
Well,
house?
well, there was opportunity for debate among the legislators, but there was no opportunity for input from those whose property was being taken.
But isn't there quite a bit of case law saying that that type of hearing where the public speaks is not critical or isn't a requisite to due process in the legislative process?
I don't believe that's the rule.
You don't think Onyx from the 10th Circuit and other cases stand for
I
that?
don't think that in these facts that would suffice.
So these facts being where you have a property interest at stake?
Yes,
Is
ma'am.
that the distinction you
Yes,
make?
Your Honor.
And your best case for that proposition would be what?
For the proposition that they needed more than just legislative action generally?
When there is a property interest at stake, yes.
I think that if again, going back to the founders' general fear of government, if legislative action can pass lots of things to take care of the state's general business, paving roads and that sort of thing, I think the standard for legislative conduct is significantly lower than legislative conduct which is designed to take either my life, my liberty, or my property. And I think by virtue of that, it's not possible to come up with a specific, they have to do A, B, C, and D. I think rather what they must do is contextual. And the more if they're going to take my life, then I believe they have to do more than if they're just going to take my property. If they're going to take my liberty, I think it's a higher standard than if they're going to take my property. But taking my property is not insignificant. Whether it's my house, my job, my car, my bank account, all of that is my property and deserves more than a weekend rush to judgment on an amendment of a gutted bill. It isn't just that they used the gutted bill, it's the lack of any notice whatsoever to these plaintiffs or anyone else like them. I mean, we're talking about a class that exceeds 25,000 people.
So the answer to my question, what is the best case you have to support your position? You've not given me a case, but rather reasoned from our founding fathers' desires. Is there such a case you can rely on? What is the best case so we can look at it in detail?
Well, I think the best case would be your own decision, in this court's decision in McMillan, and all the other cases that we've listed in our brief. And in that case, it says, quote, once the state has conferred a property interest, the property interest cannot be taken without constitutional procedural due process. In Kansas, a public employee who may be discharged only for cause has a property interest in continued employment. We agree with McMillan that a tenured teacher's right to continued employment is a property interest subject to the protections of due process. There was no due process in what the legislature did. They just did it essentially in the middle of the night with the basic precepts of the 14th Amendment are notice and opportunity to be heard.
Counsel, how is the standard you're proposing manageable at all? Because, I mean, you just suggested, for example, that a deprivation of a liberty interest actually would require more process than what you're advocating for. But virtually every law passed by the legislature, in some sense, constrains liberty. It strikes me that you're suggesting that the entire manner in which the legislative body goes about its business is inadequate.
That's not my position. I think that would be a significant expansion of my position. And I think the truth of the matter is that one of the roles of this court is to look at what the legislature did, to determine in this court's eyes and analysis whether what they did met the standard. That's always been the way it worked. The legislature does what it does at its risk for being right or wrong.
Well, let's say the legislature reduces the speed limit on the highway to 55 miles per hour. And I'm a person who really likes to drive 70 miles per hour. And they did it in the middle of the night. Like, did I have a right to be heard on that?
No, you have a right to challenge the ticket.
But I didn't have a right to have a legislative hearing and talk about, don't deprive me of my liberties.
I have a strong hunch that if they were going to lower the speed limit and they told people about it, there'd be a whole lot of folks over there complaining. If they lowered the speed limit and didn't tell anybody about it, there'd be a whole lot more people over there or here. But it requires something.
So the Constitution does protect the citizens' rights to weigh in on that issue.
I certainly hope so.
Okay.
I believe so. I've always believed so. I mean, the constitutional bedrock for takings and the prohibition on takings without significant process, if we don't have that, then we really don't have much.
Is the legal problem for you and I don't remember the citation, but the statute that where the legislature reserves the right to be able to change the Due Process Act. Because if you didn't have that, you'd be arguing that your clients earned their statutory protection. There was no reservation of the right to that, and so it's embedded in the continuing contract for their professional career.
See,
And is that the distinction between Kansas and, let's just say, the North Carolina case or something like that? It seems weird to be talking about the legislative process of notice and opportunity to be heard with this as opposed to this being a violation of the contract clause.
well,
I can't get over that.
we believed when we filed this lawsuit, and I continue to believe, that even though 5444 attempts to reserve certain rights to the legislature around property interest and contract rights, that reservation is not exercisable without due process.
But it is exercisable.
Yes,
Okay.
but they exercised it here in a way that didn't satisfy due process. They just did it.
You're well out, but I have a question, and I appreciate it that it's in the context of what you're arguing here is that the guarantee of teacher protections has been stripped away from you. But is there anything that prevents individual bargaining units from negotiating these same protections or even greater protections with their local school boards and through their contracts that way?
There's nothing to prevent all kinds of rights in a bargained agreement. The problem is that effort's been made in a number of school districts across the state with very, very limited success. So what we now have are diverse classes
Right.
of protection.
So that's so the current kind of climate here is there's differing protections depending on where you're employed.
From at will to something that approaches what was there before.
Okay.
Do you have any further questions? Counsel, we've peppered you with questions. Do you need 30 seconds to wrap up your position, or you want to wait till rebuttal?
I'll wait till rebuttal.
Very well, thank you.
May it please the court. My name is Ed Keeley. I'm here representing the defendant, Eppley School District number 492. I'm going to split my time with the intervener state, Mr. Carswell. The plan is that I would take the first 7.5 minutes and then turn over to Mr. Carswell. Procedurally, this case was filed against the school district, challenging the constitutionality of the 2014 amendments. And then at a point then after it got started, but not too far, the Attorney General's office moved to intervene. That was granted. The Attorney General's office, although we have some minor differences in our positions, basically supports the position of the school district that the 2014 amendments are constitutional. And the legislature, this year, could go back and legislate again and go back to the old system if it wanted to. It's a legislative prerogative. It's a policy matter. It's these so-called tenure rights are not constitutional rights under the Kansas Constitution. They were statutory rights. And it's been pointed out.
But there were property interests. I understood you weren't challenging that there was a property interest.
I'm not challenging it. I think
Well, I understand that. That's one of the minor differences.
I'm not challenging that before the 2014 amendments, based on decisions of this court and the way the statute had evolved from when it first was, or the act was first enacted in 1974, that this court at times had said, yeah, because the court had construed it to mean that termination or renewal only for good cause, that there was a property interest. But the property interest was found in the statute, the teacher statutes. What I'm arguing is, and it's based on KSA 725444, but I would say even without that statute, but that statute is the specific one that says there was said at the very beginning when the tenure, which wasn't tenure to begin with, it was more of if there's disputes, there can be a grievance board, or there can be some advisory or recommendations to the school board, and then over the years it built into more protections for teachers. But from the very beginning, the statute 725444 said there's nothing in this act that creates any right or contract right. And so it's obvious, and it can be changed or repealed at any time. We're not trying to create something that's going to last forever.
Well, there hasn't been a notion, as I recall in the law, and correct me if I'm wrong, that the school district could change mid-school year. Once you got past May 15th, you had a new contract, and that contract is property right. No one can dispute that. So it's not like you could come in the middle of that contract year and change the terms. You're picking it up at renewal, and then either give notice or you don't. If you don't give notice, you're stuck. And that's still the part of the law. So I don't think it's accurate to say that you can change these contract rights at any time. Do you agree with that?
I agree that you can't change them. Well, let me address this because I think it goes to the whole retroactive versus prospective and the timeline. The 2014 amendments were adopted in April of 2014. They didn't become law then, I want to emphasize they were voted on by both houses, the House and the Senate, approved by both, by the representative of the elected representatives for the people. We have a Republican or representative government that's, we elect these legislators to make those decisions. Both houses approved it in these amendments in April 2014. It was signed, I think, by the governor maybe in May, but to be effective July 1 of 2014. Okay? So there wasn't any effective date of the 2014 amendments until July 1, 2014. What happened in this case didn't happen until 9 months later. And these were one-year contracts, and so it didn't affect that contract then for 2014, 2015 for the plaintiffs. But when they were coming up to whether there was going to be a contract for 2015, 2016, then the law still says that on the May date, if you're going to non-renew, you still have to give them notice of your intent to non-renew. What is different now is that you don't have to give them the reasons, written reasons, or you don't have to give them an opportunity for a hearing. But you still had to give them notice. And so it was prospective. It wasn't, everything happened and was intended to happen after July 1 of 2014. And so it wasn't like July 1, 2014, and the legislation looked backward and took away some rights. But certainly after it became effective July 1, 2014, at that point in time, the statutes, because of the amendments, were that there was this renewal system that was different than the prior one. And one of their arguments is that, the school district should have known it was unconstitutional and should have used the old system, but the old system didn't even exist. It wasn't even in the statute books. So, but yes, you can change. You can't change something, retroactively from the effective date back, but you can certainly, as the example was about the speeding change. The legislature goes in and changes a 75 mile per hour speed limit to 55. Before the effective date, I can go 75. In one sense, I have a right to go 75 without getting a ticket. After that date, I can't go 75. It's affected my rights. But nobody can go back from the date of the effective date and say, well, you did 75 before that, and therefore you get a ticket. That's retroactive. But prospective is from the date of the effective act, which is virtually all acts have an effective date. They don't take in effect until that date, and then they apply to everybody, and somebody gets hurt. Somebody has advantages under the new law. Somebody has disadvantages. That's what happened here. And so it's based on the timeline, there was certainly no retroactive effect. They were under the new law after the effective date. Now, one thing I do want to point out before, because there's been a reference to this North Carolina case, which, as I understand it, and I didn't really even research it because it's never been an issue here, but the North Carolina case was totally argued based on the U.S. Constitution contract clause, not the due process clause. It was never raised in the petition here. It was never argued in the cross-summary judgments here to Judge Hart. It's never been an issue here, and it can't be an issue here on appeal. This has solely been an issue on the due process theory of unconstitutionality. So I wanted to make that plain.
Before you sit down, what teacher protections in USD 429 currently exist? What protects a teacher from a solely arbitrary discharge? Are there any?
Under number 4, my client, 492.
Yeah, aren't you here? Yes, your
Yes.
client. I'm sorry,
Yeah.
I meant.
To be honest with you,
492.
Yeah. To be honest with you, I don't know because I don't get involved in their teacher
I
contracts.
thought you were representing their.
For this case only.
All right. So you don't know that.
I don't know. I agree with that the act allows that bargaining. There's nothing in there that prohibits the bargaining of the district for protections.
But right now, you don't know if anything exists to protect from arbitrary
I don't.
discharge. Okay.
I don't, sir.
Counsel, I'd like to go back to the issue that we addressed with opposing counsel, and we had asked him concerning this particular legislative process, what else needed to be done to satisfy his 14th Amendment argument. My question to you is, did the legislature, in your view, do the absolute minimum to satisfy the 14th Amendment, or could they have done even less than they did here and still be all right?
Well, they certainly did, based on the U.S. Supreme Court cases and the Onyx 10th Circuit case, where it's not required to have a legislative hearing, where it's not required to have a notice broadly. I mean, those things certainly apply in a judicial sitting, an administrative, where there's two parties that are, and there's a determination, a quasi-judicial or judicial determination of whether property or liberty is taken. But in a legislative situation, it was certainly enough for the.
I understand you said it's enough. Could they have done less and still satisfy the 14th Amendment?
I don't know. I haven't thought of it that way.
Well, let's ask this: do they have to do anything?
They have to vote on it. They have to.
No, I mean, do they have to do anything?
I would say they have to debate it.
Counselor, let me ask my
I'm
question,
sorry.
please.
I'm sorry.
Do they have to do any notice to anyone or grant opportunity for hearing to anyone?
Well, I would say no. I would say to have the courthouse.
That would lead us to the point that no matter how incredibly stupid we think the law might be, we have to send them back to the ballot box. That's the only relief they have. They don't have any constitutional relief here. That's what you're saying.
Well, based on the U.S. Supreme Court decisions, I mean, And again, that would go to whether this court doesn't get into policy matters that the legislature is whether it's wise or not. But certainly they have to, I mean, the legislature, I mean, it has to be open. Anyone can attend, listen to them, have access to their own legislator. But do they have to publish it in a paper? I mean, what notice are we talking about? We have to send out emails to everybody on a list? We have to, I mean...
Counsel, let me give you an example. A bill comes over from the Senate to the House. On the floor of the House, it's amended to put these provisions in. The bill then goes to conference committee. The House and Senate conference committee concurs, and it goes then it goes back, voted on, and up to the governor. There's never a hearing. Is that good enough?
Yes, sir, under current law, under U.S. constitutional law. Because you would, I mean, there's so many bills that are passed that way every session, because it's just the nature of legislative process that as you get closer to the end of the session, there's taken from this bill, that bill. As long as you have debate of your elected legislators and they vote up or down, they voted up and pass it, then that's sufficient due process under the legislative session, except for a situation like Darling, where that was a specific legislation targeting a few specifically identified individuals for termination. That is a defect, but it didn't really have it didn't have anything about notice or hearing in that per se. It was basically legislation that targeted specific individuals, not a general class. I'd like to, unless there's
And
questions.
does that change your answer to that if, based on the subject matter of the bill? I mean, if we're announcing a new state bird at midnight or whatever, as opposed to depriving a property interest, does that change the nature of the process? Or is it the same regardless of the subject matter of the bill?
To me, it's the same. I mean, whether it's the 55, 75 mile per hour, whether it's the state turtle, bird, I mean, these, we're talking about state statutes, not the Kansas Constitution. So state statutes in general are there to be modified, repealed, replaced every legislative session. Thank you.
Thank you.
May it please the Court, Assistant Solicitor General Dwight Carswell appearing on behalf of the state of Kansas. The U.S. Supreme Court long ago established that when legislation affects a general class of people, the legislative process provides all the process that's due. Courts across the country have applied that rule to reject due process challenges to legislation eliminating tenure or civil service protections for public employees. And that same rule requires the rejection of plaintiffs' arguments here. Plaintiffs try to argue that there's some exception to that rule when there's a defect in the legislative process. As an additional matter, their original source for their argument there is the Supreme Court's decision in Atkins v. Parker. What the U.S. Supreme Court said there was they, the petitioners, do not claim that there is any defect in the legislative process. So the U.S. Supreme Court was just saying that issue wasn't raised there. It wasn't establishing a defect rule. But in any event, the U.S. Supreme Court has also been clear that legislatures are not required to hold hearings on legislation. And so that forecloses plaintiffs' defect argument.
Counsel, you would agree that when you get past the date in May, third Friday or Monday or whatever
Sure.
it is, I'm saying the 15th,
Okay.
but when you get past that day in May and you've got a contract for the next school year, the legislature can't change that contract during that school year, correct? Because that's a property right, to have that contract for that school year.
Well, whether it's a property interest depends to some extent on the terms of the contract. The U.S. Supreme Court's been clear that at-will contracts, for instance, don't.
Well, there wouldn't be anything at will
Sure.
in a contract for a term, for a school year. So the legislature can't change the terms of that contract by legislation mid-school year.
I think that would be a contracts clause issue rather than due process, but yes, I think that's correct.
Well, right now, we're just talking about property interest and then.
Well, again, I don't think, I mean, the U.S. Supreme Court's discussion of property interest in the context of the 14th Amendment looks at whether a particular contract is at will or whether you have tenure. So I can't say categorically that every contract would confer property interest.
Well, a term.
It would be a contract,
A
right?
term contract isn't at will. It's for a term.
I mean, if it provides you can be fired at any
Well,
time, that's an
and
at
it's
will.
at will, but,
Yeah.
but for a term, it's a term. Okay.
Do you disagree with your co-counsel on what the minimum would be required here for the legislature to meet the due process requirements?
I think we agree, if I heard him right. I mean, the minimum is just whatever's required as a matter of state constitutional law to pass legislation. The due process clause doesn't prescribe any particular procedures. It leaves it to states. And as long as, in this case, bicameralism, presentment, those sort of things were satisfied, the single subject rule, for instance, as long as it's validly enacted as a matter of state law, and it goes through the legislative process established by state law, the U.S. Supreme Court's decision in bimetallic and subsequent cases says that's enough.
Very well.
So my example of a floor amendment to the other house's bill and concurring and then going into conference committee and on, that's just fine.
That would satisfy due process. Yes. And in fact, I mean, there are a lot of property rights that are treated like that. I mean, if you think about it at the federal level, tax legislation, taxes are in affect property interests. Those can be settled in conference committee without hearings, especially if you think at the federal level. I mean, it happens quite a bit, and the U.S. Supreme Court's never held that sort of thing violates the due process clause. Plaintiff's reliance on Darling is also misplaced. The court there recognized the general rule, but said that case involves unique set of facts. It involves 17 particular individuals who were terminated for termination. That's clearly not the case here. That case was more like the Londoner case that the U.S. Supreme Court distinguished in bimetallic. Here, the bimetallic rule that the legislative process provides all the process that is due controls. The state also argued below that the plaintiffs didn't have a due property interest in the first place. The district court obviously didn't need to address that, given its holding. Neither do you. You could easily affirm the district court on the grounds that it gave. But if for some reason you were struggling with that rule, you could and should address whether they had a property interest. Given the time limitations, I'll just rest on my briefs on that point unless you have any questions.
Any more questions of counsel? All right, thank you, counsel.
Thank you.
And you reserve 5 minutes for rebuttal.
I'd like to respond to the inquiry from the court earlier and cite to you from our brief on page 2 that, and I'm referring to the case of Atkins v. Parker, 472 U.S. 115 at page 130. The question is whether legislative process is sufficient. Quote, this rule does not eviscerate all due process rights of plaintiff here. A federal interest remains in protecting the individual citizen from state action that is wholly arbitrary or irrational, citing Logan. Similarly, an individual claiming a defect in the legislative process might have a claim for due process violations. Likewise, in the Gaddis case, which we cite on the same page, the court in Atkins held that absent some identified defect in the legislative process, a legislature has the power to modify or rescind property interests previously conferred. It's one thing for the legislature to bequeath or give a property interest. This court has acknowledged multiple times that teachers serving the proper number of years have a property interest. That cannot be at issue here. The question then is, what process must the legislature use to take away the property right they vested in those individuals? I suggest to you our brief supports my contention, my belief that what they did in this case did not meet the minimum. In fact, it's hard for me to imagine there could be less legislative process in this taking than was given. There was no process other than a locked room, middle of the weekend, and no notice and no opportunity. It is a classic example of taking the affected folks out of the equation.
Yes. I understand your response to some of the questions about the timing. There was another legislative session between when this legislation became effective and when notice was given to you, the two plaintiffs in this case. Is that correct?
I was trying to remember earlier, I think the notice date for non-renewal, well, yes, you're correct. In 2015, there was another legislative session. My clients were not non-renewed until the spring of 2015, so the answer is yes to your question.
And so why does not the fact that there was that legislative session where there was an opportunity for additional hearings, legislation, and I know there's been legislation proposed since 2014. I don't remember if it was anything in the 2015 session or not. But does that undercut your argument? Because there was still an opportunity for your plaintiffs and other teachers across the state to push this issue in the legislature in that 15 session?
I don't think so. I don't think it undercuts our argument at all for this reason. They took their action when they took it. It became effective and harmed my clients retroactively. It took away something they had earned prior to July 1, 2014. And just because the legislature chooses not to revisit that issue later doesn't change the lack of notice and opportunity that was exercised in their decision-making in 2014. I have no further rebuttal other than...
How do you respond to Mr. Carswell's assessment of Atkins that although it spoke about legislative defects, it didn't establish the defect rule that you want to establish, that defect means something more than their procedures, that it means that there's a due process overlay that makes it defect. You understand what I'm saying? There's nothing, I haven't heard you say there was anything done here that violated legislative rules or violated Kansas law or Kansas Constitution on the operation of the legislature. The problem is due process rights. And so how do you get that overlay onto that statement from Atkins when you have bimetallic and all the other federal law that says the legislative process is enough, no hearings required?
Well, I think in bimetallic, there's no due process issue raised, for one. Secondly, we're not claiming that the legislature didn't follow its own rules here. It's just that the rules themselves, as they operated in this case, failed to provide the minimum due process required in a taking of property.
I understand your argument. What I don't understand is how you inject that due process requirement into Atkins' statement.
Well, I think the defect...
Says absence legislative defect, and interpret that to mean something else that involves due process.
Well, if you're defining defect as it must be a failure for the legislature to follow its own rules, then I don't see a defect.
Okay.
I might not like what they're doing, but I don't see a defect. But that's not my point. My point is...
Well, I understand your point,
okay.
but I'm trying to get your interpretation of Atkins.
I mean, they do a lot of things that I don't like, and I think don't meet my standard of common sense. But it's their rules. With respect to Justice Stiegel's comment about speeding, not that he's a speeder, but in his hypothetical example, the right to speed is not a guaranteed life, liberty, or property interest. That's just something that is statutory, and you don't have a right to a notice about that. You might be unhappy about it and want to go complain, but that's a statutory right in a purest sense. My life, my liberty, my property, that's different. That's property. That requires more than just middle of the night following a set of rules, but that don't offer me notice and opportunity to respond. So, in all due respect, I think they can keep you from driving faster.
Do we have any further questions? Thank you, counsel.
Thank you.
Thank all counsel for your arguments this morning. Court will take this matter under advisement.